One striking phenomenon at the moment, not seen in previous public expenditure squeezes, is the number and range of judicial challenges by way of judicial review to funding cut decisions. These range from the challenge by the Fawcett Society seeking to overturn the government's first budget, through to challenges by local authorities against squeezes on their funding, businesses against measures that affect them, and then individuals and action groups against things of concern to them. I think a very good example is a recent case involving 6 local authorities who challenged a decision to cut funding in the schools building programme. That cut was made just after the last general election, and the saving that the government wanted to achieve was £9 billion. In relation to these 6 specific authorities, which had 58 schools, the saving was £1 billion. The challenge succeeded, and the government has had to go away and think again about the decision, although the court didn't and couldn't order it to actually fund the building. There are 2 major factors that have led to this. First, over the past 30 years or so, the administrative court, the court in which judges hear judicial review cases, have become much more self-conscious and self-confident in holding the government to account. A good illustration of that has been the court-led expansion of the rules on when and how a government must consult before making a decision to change on a policy. And it was a failure to consult that was one of the reasons that the Department for Education lost in the schools building programme case. The second area is in relation to changes in legislation, and in particular 2 things. First of all, the introduction of the Human Rights Act, which has led to claims based on that, and an example of that is a challenge by 2 students to the increase in tuition fees based on their right to education. Even more important than that has been the discrimination duties now collected together in the Equality Act of 2010. This creates a duty on all public authorities effectively to take into account the needs of a number of specified groups, women, the disabled and so on, before making a decision. And government bodies have found it extremely difficult either to take account of that duty or more often to do it adequately. And again, this was a ground on which the schools building programme challenge succeeded. I think the courts haven't yet fully worked out what the public sector equality duty, that's the duty to pay due regard to these various factors, requires public authorities to do. And that creates a real challenge for public bodies in knowing how to go about making their decisions. A linked point, and this really is slightly more speculative, is whether that public sector equality duty can be used to deliver specific outcomes. Judicial review classically is about how decisions are made, not the outcomes. I think at least some claimants will seek to use this duty to edge it towards an outcome-based review. At a time when the government wishes and needs to drive through very substantial public expenditure reduction, judicial review is being used to frustrate the implementation of those cuts. From both central government and local authorities' points of view, it means that even greater care has to be taken as to how they go about delivering and implementing cuts. From the point of view of people affected, it gives an opportunity, certainly to delay and perhaps to frustrate altogether, an adverse cut affecting them.